All right, good day, everyone. This is CrimLaw, CRJS312. Today we're going to discuss Chapter 3, Punishment and Sentencing. Of course, our textbook, I'll remind you again, is Contemporary Criminal Law by Matthew Littman. I'm lecturing from the second edition, but the newest edition, I believe, is the fifth. That is the new edition that's required for the class, but I usually cross-reference older books and make sure the information is still relevant. I just like the way this is organized, so I can speak freely and move along the organizational scheme that the book has, so that way you guys can keep up as well. So let's get to it. Chapter 3: Punishment and Sentencing. So, as an introduction, in the last decade or so in the United States has experienced a shift from indeterminate sentencing to determinate sentencing, and we'll talk about the difference between the two. Determinate sentencing is sentencing where you know exactly when you're getting out. You're not sentenced in a range. If you're sentenced to 90 days, if you can count to 90, if you can scrape the wall and do the tally, you can when you get to 90, that's the day you get out. With indeterminate sentencing, you're sentenced in a range. There's usually a minimum and a maximum. And normally the way it works, at least in North Carolina, you're sentenced to the max and you're working your way down to the minimum. That's how it works. We'll talk further about that. Punishment. The legal test for punishment considers various factors, including legislative intent, whether the type of penalty has historically been considered punishment, the degree of restraint on an individual's liberty, the purpose of the penalty, whether intent is required, and whether the conduct being punished has traditionally been viewed as criminal. Now, what does it mean when it says whether intent is required? We're going to talk in a few chapters about the parts of the two major elements of crime. You have an act done with an intent, with a mind, with a mental a mindset, or what we call the criminal mind. There are differing levels of the criminal mind or the mens rea. So something you do on purpose is different than something that you did inadvertently on accident. Now, it could be the same result. So if you kill someone on purpose, it's different from if you do something inadvertently and someone dies as a result. It's the same result. Someone's dead. You've caused the death because but the difference is in one crime you did it on purpose, as opposed to in the other crime. With the other crime, you did it and it was inadvertently. You didn't know that was going to happen. So you're not punished as harshly. So that's when we talk about whether or not the crime requires an intent. And there's some crimes that don't require an intent at all. We'll talk about those. Those are strict liability, where really you're just punished just because something happened, and what the law is trying to do is to prevent the harm because of that's caused by the action, rather than why the action or why the act had taken place. So in those situations, normally strict liability crimes are not punished as harshly. But we'll get to those type of crimes later in the book. But I wanted to just highlight what the book said there. So what is required? So if the crime, the mens rea or the mental state required for the crime to have been committed does play a factor in how it's going to be sentenced and what the punishment is going to be. Also, with punishment, whether a statute is considered to impose a civil disability or criminal punishment, can have important consequences. So that means some statutes are designed, with punishment statutes are designed to essentially make a person pay something back as opposed to punish them. So in those situations, it's all about legislative intent. And we talk about legislative intent because the punishments for crime are 100% legislatively made. So the crimes are codified and they're classified, and we'll talk about the two I don't want to say elements. What's the word? We'll talk about the two variables that are included or that are considered when it comes to determine what a person's sentence is. Um, let me see. Pose. Yeah. We'll talk about those. So one is the classification of the crime itself, and the other is the individual person and their criminal record. Crimes themselves are classified based on level of importance or seriousness, and depending on how high they are on the hierarchy, they're going to be punished harsher as opposed to things that are lower on the hierarchy. So what the legislature does in writing laws and telling us what's illegal and what isn't illegal and how it's going to be punished is they determine how things are going to be punished by essentially classifying the crimes and telling us how they're going to be punished. Purposes of punishment. Purposes of punishment include retribution, deterrence, rehabilitation, incapacitation, and restoration. Now, when we talk about, let me see, okay. When we talk about, what's that, retribution, that essentially means just desserts. A person gets what they deserve. They committed this bad act. Now they need to be punished. So that's kind of, when we talk about retribution, that's kind of that eye for an eye situation. Deterrence is also a purpose of punishment, and there are multiple. There are two main different types of deterrence. There's the individual deterrence. Well, what do we need to do? How do we need to punish this person to make sure this person gets it? And they say and make this person say, I want to turn away from a life of crime, and I don't want to commit this crime anymore. I'm done because of how I was punished. And then two is public deterrence, so the deterrence of a whole class of people, or everybody. So if everyone sees that this person has taken an action and they got punished, they're gonna say, I don't want to be punished, so I'm now deterred by seeing this guy's punishment, and it's gonna keep me from now committing the same act. So deterrence is just in criminal punishment, they're just trying to decide what is necessary to keep the person and the public at large from committing the crimes. Rehabilitation. So sometimes the purpose of certain punishments and things that are included in punishment statutes and sometimes even conditions added on to probation, it's about giving rehabilitation to not just the victim of the crime who deserves to be made whole, but a lot of times it's for the actual perpetrator of the crime, the actual defendant. Because what I've realized in my practice is what I would say is that people, my clients, the bulk of them, 90+% of them aren't inherently bad people. They're people that make choices based upon, they make decisions based upon the set of choices and the options that their life and their circumstances have given them. So even though they make decisions and of course the decisions are 100% voluntary, they're making them because of their current situation. So a lot of times we can sit outside and judge a person not being in their situation. And that's a lot of times that's what happens in the court system. What I realize when in rehabilitation, what you're trying to do is fix the person's situation, help them to help themselves get out of the situation, so they won't be faced with those types of decisions that make them break the law. Then we have incapacitation. Incapacitation is when you essentially take a person from society and say, hey, what you did was so dangerous, we got to take you away. That can be life imprisonment without the possibility of parole, like a permanent timeout, or it could be death, capital punishment. Next, we have restoration. We talk about restoration, we're restoring. So essentially, we're making society whole, making sure society is paid back through either restitution, maybe some type of community service, making sure the defendant now has to give back in some type of way to make sure the victim is made whole. So those are the purposes for punishment. Next, we're going to talk about sentencing. A judge may sentence an individual convicted of a crime to imprisonment, fines, probation, intermediate sanctions, or capital punishment. Now, what does all that mean? Act imprisonment, that's what we say active time. That means you're taking the adult, I call it the adult time out. We're now taking you away from society and you have to go into custody. That is imprisonment. Then you have fines. Sometimes the courts can just impose fines and hit you in the pockets and say, hey, because you've committed this act, you've been found guilty of committing this act, you now have to pay society, pay the court system. Of course, they determine what you owe, but you have to pay the court system. And sometimes people just get sentenced to pretty much all they have to do is pay their fines in a timely manner. Probation. Probation is when a person is sentenced to active imprisonment, but that sentence is suspended. We say suspended. Imagine a boulder being hanged over a person's head everywhere they go, and the minute they do something wrong or they're found to have violated, somebody cuts the rope that the boulder's hanging on, and it drops on them and crushes them. So think about that as being a suspended sentence. So you're walking around, in probation with a which is what they call a suspended sentence. A person's walking around with this boulder or with time hanging over their head for a certain period of time. Of course, that time can't be open-ended. It's not forever. So probation is starts, but it's supposed to have an end date. And in most states, that end date is limited to a certain amount of time. Unless an extension is needed. And of course, the extension has to be justified through the judicial system. The system doesn't. Judges can't just extend because they arbitrarily want to extend the person's time and keep them on probation longer. But through probation, like I said, you have a suspended sentence, and you're walking around, and you're ordered by the court to do to meet certain conditions, do certain things, and not do certain things. Not use drugs, and you're subject to urine analysis, meaning that every month or whenever you go to see your probation officer, you have to give a urine sample that's going to be tested to see whether or not you have ingested any illegal substances or substances. Because even though alcohol is perfectly legal, a judge can tell you that you're not allowed to touch it and consume it. So they can do tests to see if you've even consumed alcohol. So it's not just about weed and other drugs. It can be things that are legal, but they want to make sure you've been ordered by the court not to put it in your system. Then from there, we have intermediate sanctions. Intermediate sanctions is a tougher type of probation. You have that sentence hanging over your head, but the conditions are much, I don't want to say much harder, but they are more labor intensive. You have to do something. Go do community service as a part of your probation. What else? Go get a GED or go through a GED program. So that's the extra things that the court puts on top of your probation. Some people say it's punitive, meaning it's meant to punish and make it harsher. But sometimes it's meant to help you to get yourself on a better footing. So once this probation and this thing is over, you don't have to worry about kind of getting dropped off in no man's land and being left out now that it's over, and probably having to make the decision to commit more crime to make ends meet. Also, an intermediate sanction that has will be talked about or has this happened before is what we call split sentencing or shock time. Essentially, what it means is you're on probation, but we're going to have you go into jail to do part of your time and then get out, and you'll be on probation. So it's a split sentence. So you're put in jail for a weekend, or you have to do a certain number of weekends, or go in straight right now for however many days, and when you're done, you're on probation. So they're not going to give you the entirety of your sentence. They just give you a fraction of it. Get out. That lets you know what jail feels like. You've been in there. Don't go back. Now go out and do the right thing on probation. So that's another type of intermediate sanction. And then you also have capital punishment, and that is essentially the death penalty. Of course, for you to be sentenced to the death penalty in most states, is not just the crime you committed, but there's only certain crimes where you can get the death penalty. Murder being pretty much the only one. In North Carolina, at least in state law. Sorry about that. But before they can give out capital punishment, a certain set of aggravating factors must be either agreed to, or which they're probably not going to be because death's on the line. But aggravating factors have to be proven beyond a reasonable doubt to determine. So those aggravating factors have to be met by the facts for the court to even consider it in most jurisdictions. So evaluating sentencing schemes. Several considerations may prove useful in evaluating sentencing schemes. These include proportionality, individualism, disparity, predictability, and simplicity. So we'll talk about proportionality. We always want to make sure that the allowable sentence that a judge can give, by statute, is proportionate to the crime that's committed. We don't want a kid stealing some 5-cent bubble gum from the store to get life in prison, right? So there's proportionality. So that means the crime, the punishment has to be proportionate to the crime itself. Then we talk about individualism, making sure each case is heard on a case-by-case basis and each person is sentenced, even though there's a classification of crimes that says how a person is supposed to be sentenced. There's also, and we'll look at a sentencing chart, we also consider who that person is individually when it comes to like their criminal record. So that's a means of looking at a person as an individual. What is their criminal record like? How many prior convictions do they have? What were those convictions for? Are they convictions for the same type of crime he or she's in here for now? So that's individualism when we sentence a person not as a class of people, but we consider that person, what they did and who they are and what their criminal record is. Disparity. We have to consider the fact that there's been a history of disparity as far as when it comes to black and brown people being sentenced more harshly, and the fact that we have a history in America of our criminal justice system not giving people a fair shake or treating people differently because of a distinguishing characteristic like race. Then from there, predictability. We want, in sentencing, we want the sentence to be predictable. I want to be able to tell my client, this is the crime you're charged with. This crime it falls within this class. I could be able to look at their criminal record and say, well, because your crime is this class of crime on the hierarchy, and your and your criminal record says you got this many convictions which makes you a level whatever, you're going to be sentenced where in the intersection of the classification of the crime and your record level. So that makes it predictable. I can advise my client on what he or she is facing just based upon that. So we want clients, at least as a defense attorney, we want them making informed decisions. So knowing what they're facing, and based upon predictability, and being able to make decisions whether or not to go to trial from that. So that's predictability. Then simplicity. We want it to be a simple. We don't want it to be a super intricate system. We want it to be something where we can figure it out quick, and so we only have 2 variables that go in there. And of course, there are other variables that come in when a person's sentence can be aggravated. We'll talk about that called aggravating factors. Approaches to sentencing. There are various approaches to sentencing, including determinate sentencing, which we talked about, where it's an exact number of days, when I'm getting out on this day. Let me see. Then you have mandatory minimums, which kind of which says this person has to do at least this amount of time, so he's not even going to be considered to be let out of jail until this amount of time is spent in jail. Then from there, he's working his way down, or he either gets out after that amount of time, or he may even have more because he's sentenced in a range, which is what we call indeterminate sentencing, where you're sentenced to a minimum and a maximum. And essentially that maximum is your sentence, but you have to, through good behavior or whatever, you can work your sentence down to the minimum, the statutory minimum. I talked about indeterminate sentences. presumptive sentences and presumptive sentencing guidelines. So presumptive sentencing is sentencing where there are pretty much no aggravating factors, no mitigating factors. It's just on the paper. It was sentencing you like the paper says. So it is what it is. So and let's talk about sentencing guidelines next, and then I'll show you some examples, at least the North Carolina misdemeanor and felony examples, and I'll also post those with this lecture so you can pull them up and look at them for yourself. Determinate has replaced indeterminate sentencing as the primary approach in the United States. This reflects a shift from rehabilitation to retribution. This reflects a shift from rehabilitation to retribution, deterrence, incapacitation, and treatment of offenders. Sentencing guidelines provide for a presumptive sentence that reflects the gravity of the offense and offender history. There may be a downward or upward departure from this presumptive sentence based upon mitigating or aggravating factors. Recent Supreme Court decisions have resulted in these guidelines being considered advisory rather than binding in certain jurisdictions. Now, first, let's look at the North Carolina felony sentencing chart. So, technically, the North Carolina felony sentencing chart, and then there's going to be a copy of this as well. You can there's going to be a PDF of it. So technically, for felonies in North Carolina, sentencing is indeterminate, meaning there's a max and a min, right? Or a min and a max. You're sentenced to 4 to 6 months. What that means is your behavior or the DAC has jurisdiction over determining when you're going to be released, but it has to be between 4 and 6 months. And now through the Justice Reinvestment Act, they've also added what they call post-release supervision, where a person, when they do their full amount of time, when they get out, they have another 9 months, an extra 9 months hanging over their head, and they're put on post-release probation or supervision to make sure they can re-enter life in society with a watchful eye on them to make sure that they don't recidivize. And recidivize means commit crimes again or commit that crime again. So, two variables in what I call it structured sentencing, but they call them sentencing guidelines. Two main variables. The first variable is the classification of the crime itself. And remember, I said before, crimes are classified by the legislature or the governing body of the jurisdiction. And of course, North Carolina would be the state legislature. They're the ones that define what a crime would be. If they feel like it, they can adopt definite common law definitions of crimes and include those and then classify them. But classifying is determining their level of seriousness and how hard you're going to punish it based upon the level of seriousness. So you have the classification of crimes as one of the crime itself as one element, or I can't think as one variable. And then the next variable is that person themselves, their record, a person's criminal history. So if you look at North Carolina, from the bottom to the top, so at the top, you have the most serious felonies, like murder and stuff like that. Those are Class A felonies. And we work your way down, Class A, then you got B, B1, B2, C, D, E, F, G, H, and I being the lowest, lowest level felony. So every crime in North Carolina, every felony crime in North Carolina is classified somewhere between I, which is at the bottom, and A. So the legislature predetermines how the crime is going to be classified. So at the time a person is charged, when the charge is read out, you're charged with felony possession of marijuana. That is a Class I felony. So I can look in the statute book and it tells me it's a Class I felony. So that question's answered. That means that this person is found guilty of that charge. They're going to be sentenced along this line. Now we're going to go across the top of the page for the next element. That element is a person's record level. In other words, what their criminal record is. Level 1 is essentially, no convictions, or it's actually a point system, but the point system is determined by the amount of convictions a person has, and then what classification of their prior convictions they have. So if a person just, there's certain level of misdemeanors that aren't even considered when they're determining felony sentencing points because they're low-level misdemeanors. Now, your higher level misdemeanors and your felonies, any of those convictions are now going to count against you in felony court. And depending upon what the level of the conviction is, it's going to be multiplied by a number 1 through like 3 or whatever. And whatever that number you get at the tally, at the bottom, that's going to be your point value. So of course, once you get points, then you go across the top, and so 0 to 1 point. So if you have 0 points, that means you haven't had any convictions of any crimes that are even considered, either no crimes at all, or your convictions may be low-level misdemeanors that aren't even considered for felony sentencing. So that means you would be a level 1, because from 0 to 1 point. Then to be a level 2 is anywhere between 2 and 5 points. Then to be a level 3, 6 to 9, 4, 10 to 13, 5, 14 to 17 points, and 6, 18 and up. So what that means, if you're charged with a Class I felony, and let's say you are a level 2, you might have a prior, let's say you got a prior Class H conviction on your Class H felony conviction from a few years back. Now you're in trouble again for possession of marijuana, and you're either going to plead guilty, or let's say you already pled guilty. Now, how are you going to be sentenced? We go and let me see. I don't have the separate sentencing like the what do you call it? The equation sheet where you actually factor that in. But let's say you are a level 2 because you got 3 prior points. So to be a level 2 is anywhere between 2 and 5 points, right? So you got 3 points. When we look at your conviction, your criminal record, and it's a Class I. What that means is you're going to be sentenced not in the 1 box, or the record level 1 box, but record level 2. So Class I, and then go over to run down the page down to level 2. And this is where the classification of crime intersects with the prior criminal record of that individual. That's what we're talking about. We talked about the individuality. So people get sentenced based upon what they themselves did, not their race or anything else. What is your criminal history? Now, is there still, even with structured sentencing, yes, there is still a minute amount of room for racism, and I'll show you how there still can be racism or bias in sentencing. It's just that with structured sentencing, even though it doesn't necessarily end bias in sentencing, it at least reduces the effect of it. So even if you are biased, the most you can give a person with the same record, with the same crime, with no mitigating factors or no aggravating factors, and we'll talk about that. There's just straight presumptive sentencing. The difference in what you can give a white person versus a black person in the same situation is maybe a month or two. The difference isn't so crazy that it jumps out. But is there still bias in sentencing? Of course there is. Remember I said presumptive sentencing, so I don't know if you can read, and I'll provide this for you. But if you look, Class I level 2. So you have 3 letters at the bottom, and let me see. So at the bottom here, we have what we call your mitigating sentencing. So if there are mitigating factors that apply to your case, and even the mitigating factors are even denoted and enumerated in the statute. If you have mitigators, let's say you are guilty of the crime, but based upon what happened and whether or not you helped police or you did something or you took responsibility early, those certain mitigating factors in the facts can be used to help you out. So that means you're going to be sentenced at the down here on this bottom line, and you see it's less. This is like 3 to 4, 4 to 6, or 6 to 8 at the top, and we'll get to what those other ones mean. Now here in the middle area, you see how it is kind of emboldened a little bit. That is the presumptive range. That's what we call all else being equal, no aggravators, no mitigators. This is just what the normal punishment for this crime. That's what that is. And then above that, get the focus, I'm sorry. Above that, on this next level, that is what we call aggravated sentencing. So you see within a box, one box. So it's a Class I felony. You're level 2 for sentencing. Your sentencing is still open to a whole lot of change. Like the least you're gonna get if you get active time is 3 months, and and all these are minimums. These aren't even the maximums yet. So the lowest minimum you can get is 3, and the lowest maximum you can get is 8. But you'll be sentenced based upon other factors and other facts in the case that may mitigate or aggravate somewhere in that box. So when I go see a client, I can tell them based upon, I look at their prior criminal record, what they've been convicted of, and it's on paper. So it's pretty easy to see what that is. And then I know the classification of the crime they're charged with are going to be pleading or they're found guilty of. So I can tell them what to expect if they're convicted just by going to this box. And then it also allows me a little bit of control because I can now figure out what's going on and what can help my client mitigate the situation so that maybe instead of being sentenced up here at the top or down here, they can be sentenced at the very bottom. And that's what we call the mitigated range of sentencing. So you see that. I'm going to give you guys a copy as well. So now that's structured sentencing, and that's felony structured sentencing in North Carolina, which is indeterminate. So as you see, those are minimums. Then there's another chart. I know you're like, wow, we're going from chart to chart. This big chart with all these numbers on it, that gives you the maximum that's going to go with whatever minimum is chosen. So remember I said for that Class I level 2, a Class I felony conviction for a level 2 offender, remember the lowest minimum they have is 3 months. They can get is 3 months. What's that mean? That means that person, if they get a minimum of 3 months, the automatic maximum, as you see here, let me get it close enough, is 13 months. They get a minimum of 4, 14 months. A minimum of 5, 15. A max of 15. A minimum of 6, the max is going to be 17, and so on. And there's a whole chart that determines that stuff. So if a person is given a minimum of 3 months active, the maximum is going to be 13 months. Now, really, in North Carolina, they've changed it. That 13 months, the last 9 months of that 13 months, so you subtract 9 from it, that is post-release supervision. What they're saying is you get out of jail and you're still not done because you have 9 more months hanging over your head in case you violate your post-release supervision. So post-release supervision was designed to give people just getting out of prison a little bit more guidance, not just letting them walk out the front door and saying, okay, you don't have anything, but go out here and live. It's saying, let us help you get back to society, and let's keep a watchful eye on you to make sure you don't get back into what you were in that got you in here. So that, and we'll give you a certain amount of time. You might have post-release supervision for, like I said, 9 months. And if you are found to have violated the post-release supervision, if you're found to have violated any condition of post-release supervision, then your post-release probation officer, supervising officer, can now bring you back before, well, it wouldn't be the court at that point. It's back before the DAC, the Department of Adult Corrections, to determine whether you're going to now have to come back in and do the rest of that 9 months. So it would actually be 3 to 4 plus 9. So you have a minimum of 3, a maximum of 4, plus 9 months post-release supervision. That's why it reads 3 to 13. And do your math. Of course, 4 plus 9 is 13. So that's North Carolina. I know that's a lot, but I'm going to leave this out here for you. Then another thing, you see in these boxes, you see a C. There are 2 types of letters. There's the C, the I, and the A. C means, as it says here, community punishment, pure probation. In other words, stay out of trouble, and just come back. As long as you ain't getting any trouble, it is what it is. You don't have to worry about going to jail. Then you have I, intermediate. Remember, we just talked about intermediate being probation with extra conditions. It's a little bit tougher. The court's asking you to do a little bit more, community service. Go to a day, we call it a day reporting program to help you get on your feet, to get your GED or get right. Parenting classes in certain situations. What else? Anger management classes, drug classes, all that stuff is in the intermediate box. Or a split sentence or a dip where you have to go in for a little bit and come out and be on and still be on probation. Then you have the big A. This is active punishment. That's what we call active incarceration. So within these boxes, the C, the I, or the A in the box, or them not being in the box, determines the type of punishment that the judge can give you upon sentencing. So if you got a class I felony and you're a level 2, the judge cannot give you. There's no A in the box, so the judge from the bench when you're first convicted can't even give you active time. All the judge can do is either give you straight up probation or community punishment, or intermediate or community punishment with the I, which is intermediate sanctions. So you see, so the punishment is all lined out. The amount of time and the range of time they can give you, and the type of punishment they can give you. Now, just because you're in this C or CI box doesn't mean that you couldn't eventually go and get your time and go do active time. What it does mean is you're going to be on probation first, and you're going to have to violate before you come back to court, and you may be given that active time. So they just give you a probationary shot. Now we move over to the other boxes, and we have I and A. What that means is the court can either give you intermediate, or they can also put you in jail. So if you go in front of a judge and you do let's say if I do a plea deal where we don't, in the plea deal itself, me and the DA and my client don't already agree on exactly what the punishment is going to be, and we leave it up to a judge, the judge has options. The judge has his time over here, the different type of time he can give a person based upon aggravators or mitigators, or if it's presumptive. So he has that range of minimums. And the judge can decide, I'm going to put him on probation with intermediate sanctions, or I'm giving him that A, or that active incarceration. So you see how it works. So there is still within these boxes, even though it's heavily structured, or the guidelines are heavily structured, there's still some room, and the judges do have some discretion. It's in that discretion where sometimes biases can come in, and some people can be sentenced differently than others. But like I said, you see the difference in the amount of you're essentially talking about a number of months in the box. So even if a judge is sentencing based upon a bias, the amount of time or what he could do to you based upon that bias is not that much different. And in the IA boxes, intermediate and active boxes, I guess it's a little bit different there, because that means a judge can put some people straight in jail and then give some people probation. And everyone that gets on probation doesn't end up going to jail. As a matter of fact, I would say more likely than not, people are put on probation, and then, I don't say more likely than not, I don't know that, but there are people that are put on probation and never violate. They're put on probation. They visit their probation officer. They never violate. They get a job. They do what they're supposed to do. They pay their court costs and fines and what do you call it? Restitution. They pay all that back, and they do what they're supposed to do on probation, and they finish probation without ever worrying about it. So there is kind of a big difference between in an active sentence and a box that says you can give someone either active sentence or probation. So if a judge wants to be biased, a judge can. So let's see, 8 to 10 months active is much different than 8 to 10 months hanging over your head and you never even have to go into jail because you're successful on probation. So there still is there still is a little bit of a disparity. If a judge wants to be biased, he can sentence someone harsher. But for the most part, the time itself, there's really not much difference. So same thing. We look at now with North Carolina's when it comes to misdemeanor. This is the misdemeanor sentencing chart. As you notice, these misdemeanor sentencing charts, they're not sentenced in a range. These are determinate sentences, 1 to 10 days. So you're sentenced to a matter of days, and it's exactly that amount of days. If you can scratch the tally on the wall, and every time you get you scratch 4 times, and the 5th you scratch it out, that's 5 days. You do that, and until you get your time, until you're done with the amount of time you're supposed to serve, amount of days, and you get out. Now, in misdemeanor in North Carolina, the classifications are 3 being the lowest, all the way up to the most serious offense, A1. So you got A1, 1, 2, and 3 at the bottom. So you see that? So misdemeanors are classified as either A1 misdemeanor, which is a step right below a felony. If the class I, if this was a whole sheet, the I felony would be right here above the A1 when we start the felony sheet. But you got A1, then you go down to level 1 misdemeanor. Then you have level 2 misdemeanor and level 3. So all misdemeanors are classified as any one of these 4 classifications. So once again, you have that's across from top to bottom. Then from left to right, you have the levels. Now, with misdemeanor convictions, it counts every type of conviction you ever had. So a level 1 is a person with no prior convictions. So level 1 has no criminal record. A level 2, Roman numerals you see here, is a person that has between 1 and 4 prior convictions of any type of crime, and that does include minor traffic offenses or infractions. And then level 3, which is the worst at the far right, that's anyone that has 5 or more prior convictions of any type of a crime that does not include traffic infractions. Anything that has to be more serious than that. So on the sentencing chart, a person, if a person is convicted of, let's say, assault on female, that is an A1 misdemeanor. If that person has never been in trouble before and has no criminal record, they're going to be sentenced in this first box. Because of the seriousness of the crime, this is a CIA box. That means the court can either give them probation, intermediate sanction as a part of probation, or active. Now, if a person is convicted of a class 3 misdemeanor, and that would be the lowest level misdemeanor, would be simple possession of marijuana. So marijuana less than 1 1/2 ounce. A small amount of marijuana. Like they got a blunt in their pocket, they get arrested and they get convicted. That is the lowest level misdemeanor. Actually, right under level 3 would be like traffic infraction. So it's very low. If that person is convicted of a level 3 and they are a level 1, you see this is C box. That means they have to get probation first. Doesn't mean they can't eventually go to jail, but before they go to jail, they have to have been on probation and then messed up on probation. Then they get sent to jail. As you can see, the time is low, anywhere between 1 to 10 days. So this is a misdemeanor sentencing chart in North Carolina. So that's how sentencing guidelines work. Now, those are North Carolina sentencing guidelines, but where federal sentencing guidelines and guidelines of other states are pretty much comparable to that. Now, they don't have the same numbering system, but it's 2 main variables, the classification of the crime and then the criminal record of the person. So what their criminal history is. As you see, nothing in here said anything about race, whether they're black in a level 1 or white or Jewish. It's individual in the sense that it's just you, not your race. It's what your record is. In other words, how you look on paper. So, truth in sentencing. Let me see. Make sure I finish this up. Okay, sentencing guidelines provide, we talked about the presumptive sentence. Okay, recent Supreme Court decisions have resulted in these guidelines being considered advisory. In some situations, they're advisory, but in North Carolina, it's not. It is what it is. The judge has to follow it. So, truth in sentencing. Truth in sentencing requires that prisoners serve a significant percentage of their sentence. The federal government provides funds to construct prisons to states that guarantee that prisoners serve at least 85% of their sentences. Now, of course, because of jail overcrowding, now, once you're sentenced in a crime, the way a judge sentences, and I won't say once you're sentenced, once a person, I'm not speaking that, once a person, a defendant is found guilty and they're sentenced, if they're sentenced to active time, and even if they're not, even if they're, so when the sentence is read out, they're always sentenced. So you're given, if it's misdemeanor, you're given, I'm going to sentence you to 10 days in the custody of the Guilford County Sheriff. What that does is the judge is now telling the person who's going to have jurisdiction over them if they get active time. Then from there, they may either make it active where you go to jail now, or that sentence is suspended and you're now placed on probation, either supervised or unsupervised probation. So, let me interject with the difference. Unsupervised probation, I'll do that first. That's pretty much when you don't have a supervising officer. All you got to do is stay out of trouble, do what the court says. The court may give you, a certain amount of time to pay your fines. As long as you do that and stay out of trouble and you're not back for anything else, then essentially you get to go home, pay your fine, and after a certain amount of time, it's done. It stays on your record, but because you convicted, unless it's expungible, but we're not going to talk about that. But you don't have to worry about the possibility of going to jail. Unless you don't do those things. But then with supervised probation, you're now under the jurisdiction of probation and parole. So in North Carolina, that's the Department of Public Safety and probation and parole. So the judge, essentially, by saying supervised probation, the judge now puts you into their custody and care. So now they can assign you a probation officer, and of course the judge reads out the conditions, the stuff you can and can't do, what you're subject to. Urine analysis, can't do this, can't do that, you might not be able to congregate or socialize with this person you might have committed a crime with, or something like that. And the probation officer's job, or the probation department's job, is to give you a supervising officer to make sure they hold you to that. Their job is to enforce the conditions of the court. If you're found outside of the conditions or found to have violated one of the conditions, they now have the jurisdiction over you to now bring you back to court. They file a violation, serve you with the violation. They can arrest you and put you in jail for violating, or they can just serve you and say, hey, now you got to come back to court and explain to the court either that you didn't commit this violation, or if you did, you might want to have a good explanation as to why, and maybe you were justified. But you got to come back to court. So that's what they do. So that's supervised probation. Let me see. Okay. The thing about it, now I said all that about jurisdiction because once, let's say if you're sentenced for a felony, in North Carolina, the Department of Adult Corrections is gonna have jurisdiction over an adult that's sentenced for a felony. So the judge is gonna say, I'm gonna sentence you to 3 to 14 months. That sentence is active, and you're in the custody of the Department of Adult Corrections. That sentence right there says who is going to have jurisdiction over you. So Now, once the judge gives that entity jurisdiction over you, they now decide where you're going to go to serve your prison time and what would be your conditions for getting out. As a matter of fact, sometimes you won't even serve your whole minimum. You definitely won't get anywhere close to the maximum, because a lot of times, depending on how long you have to serve, the prisons may be overcrowded, and if you can serve a certain percentage of your time, they just get you out of there. Like, oh, he's out. Put him on. He's now on post-release supervision. So the judge essentially gives them unfettered jurisdiction and discretion over determining how much of your time you're going to do. So that's why they have to have truth in sentencing guidelines and statutes to make sure people are actually doing at least 85% of their jail time, or the prison time they're assigned. Victims' rights. The victims' rights movement has resulted in provisions in federal and state laws to compensate for injuries, expenses, and restitution. It also provides for the right of victims to be informed of developments in regards to the prosecution and sentencing of offenders, and the right to participate in the trial through victim impact statements, and also the right to be heard and say something at sentencing in these cases. So the victim has rights. They're not constitutional rights, but by they're given statutory rights to be present and be heard. The Eighth Amendment. The Eighth Amendment is the constitutional amendment that governs sentencing, bail and sentencing. And it pretty much just talks about being proportionate. The Eighth Amendment to the United States Constitution prohibits cruel and unusual punishment. The cruel part meaning, can't be maiming, cutting heads off and crazy stuff like that, like the old school medieval stuff. And unusual essentially means is not just unusual in the verbiage. It also is talking about proportionality. So in other words, stealing 5 cent stick of gum shouldn't get you life in prison. So proportionality is kind of a part of the Eighth Amendment as well. This clause limits the methods employed to inflict punishment, restricts the amount of punishment by proportionality that may be imposed, and prohibits the criminal punishment of certain acts. The Eighth Amendment is not limited to punishments that were prohibited at the time of the adoption of the Eighth Amendment, and draws its meaning from evolving standards of decency. That's one smart thing about the Founding Fathers and the people that gave them the Constitution and told them how to do it, because they had no history lesson, real quick message. They didn't exactly have the one thing about America. Before the Revolutionary War and America was created, you look in antiquity and history, there's been no other country that has governed itself like America. There have been a whole bunch of monarchies like England. So pretty much every country back, pre in the colonial times and before, everyone at one point in time had a king. And then certain countries might have had revolutions where they moved away from it, but no one has ever had a democracy like America. So America was something new. Bicameral legislatures and stuff like that. That's something that the Thomas Jeffersons and the Thomas Paines and the Alexander Hamiltons and the George Washingtons, that there was no example for it. They literally created a government, and they had to have help creating the government. Now I need to get another old textbook for state and local government, and it'll give you an idea of who might have helped them. But I'm not going to go into all that. But I said all that to say the Constitution itself is a living document, meaning that it's a document that's designed to change with the times. So, back in the day when the Constitution was first written, we didn't have cars, we didn't have computers, we couldn't pre-record and download lectures on YouTube. So as the times change, the Eighth Amendment is also supposed to be flexible and be adjusted to the times. That's all that means. The Eighth Amendment is, like I said, that's why it's not limited to punishments that were prohibited at the time that it was adopted. And it means that it evolves and the standards evolve. The death penalty, also called capital punishment, is not prohibited, meaning it's allowed by the Eighth Amendment, but how it's done is what the Eighth Amendment, that's what the Eighth Amendment standard kind of governs. Capital punishment, however, is restricted to murder, only murder, so you can't get capital punishment for stealing gum or rape. So essentially, it's really only limited to murder. So you got to kill somebody to even be considered for the electric chair, gas chamber, or capital punishment. However, it is restricted to murder in which aggravating factors outweigh mitigating factors. The administration of the death penalty is subject to various procedures intended to ensure that capital punishment is imposed in a proportionate fashion. Courts generally have held that state and federal statutes providing for punishment for a term of years, such as 3 strikes and you're out laws, and laws specifying the length of sentences for drug offenses are proportionate to the offender's crime. So it's all about proportionality. Under the 8th Amendment, individuals are to be punished for their criminal acts rather than for a personal status. What does that mean? A person that is on drugs, might call them a drug addict or a crackhead, you're not going to jail because you're a crackhead. You're going to jail because you're a person, and you're a person that at the time you were encountered by police, you were found to have been in possession of crack. So it's never about punishing a person for who they are and what they're battling with, but it is so you're punished for actions, and we'll learn is that possession is technically an action. Knowingly possessing something, that is an action. If I know my keys are in my pocket right now, so I knowingly possess my keys. Now it's not illegal, but that possessing something and taking control of something is an action, just the same as murder or killing somebody or shooting somebody. It's an overt act. So you're not punished. So people who are on drugs that go to jail, they're not in jail because they're on drugs. They're in jail because they possess drugs. Now, them being on drugs probably made them more likely to have drugs and be in possession of drugs, right? So being an addict did put them in that situation, but that's another thing about punishment. When we talked about earlier, rehabilitation. If this person has a situation where they're an addict, which means they're more likely to probably have drugs on them, what the system has things they try to do to try to fix that person and get that person out of that cycle. Equal protection, and this is the last part. A judge may not base a criminal sentence on a defendant's race, gender, religion, ethnicity, or nationality. A defendant seeking to establish that a statute that is neutral on its face is in fact a violation of equal protection must demonstrate both a discriminatory intent and a discriminatory impact. So that's the hardest thing about proving racism in sentencing. So you saw those structured sentencing, the structured sentencing guidelines. So there is room for bias in both of these, right? But like I said, the bias is very little. It's a matter of months, right? Or whether you get probation or not. So the thing about it, there can be a person that lands in the same box, same situation, even the same aggravators or mitigators, and they can still be sentenced differently, especially in a box that has an I and an A where the judge can either give probation or active time. Yes, you can look at a judge's numbers and say, wow, this judge is giving all the black people, everybody that's black in front of him with the same situation, all of them are getting active sentences, and all the white people in front of him are getting probation. That can be true, right? But the hardest thing about proving discrimination is that the only way to prove discrimination is going to cause a reversal of the case is that so that you also have to prove discriminatory intent. So it's not just about proving the discriminatory impact. Something can look discriminatory, and you can see it on the paper. Like, oh, white, this person was white. Everybody that's white is getting probation. Everybody that's black is getting active time. So you see it. The only problem is you have to prove that the judge did it on purpose and did it with the discriminatory intent. That's the problem. It's very hard to prove discriminatory intent. So no one ever says the N-word or says I hate black people as they're sentencing a person. So that's the problem. You can hardly ever prove discriminatory intent. You almost gotta pull the Klansman robe or find it in the judge's closet or something, or figure out what the judge tweeted or something like that. And you think about the days when we didn't have Twitter and all this stuff. So it's almost impossible to prove this discriminatory intent. So you can never prove discrimination without proof, because the law says you got to prove intent. And you can't just prove the discriminatory impact, but you also have to prove the intent. So that's it. Chapter 3, punishment and sentencing. Once again, I'll show you the website for the book right here. www.sagepub.com, Lippman CCL2e. You can go get the look up the outline or print the outline for the chapter. And you can, once you print the outline for the chapter, you can also click on the chapter, all the resources for the chapter, and do the quiz that goes along with chapter 3. It's like a little online quiz on the website. And from there, if you do that, you would have already done whatever, because I actually, in my midterm and my final, I actually include questions regarding every chapter. So it ends up being, especially my final, is cumulative. So I'm going to, every chapter, there's a question from that website somewhere. Now, you don't know which questions, because, of course, each chapter has like 15 questions, and the most I pull from any chapter might be 3 or 4. So you're not going to know which ones I use, but if you do all the multiple choices, you'll know that one of them is going to be there. But you guys be good, and I'll see you guys later.